Why agreements or general power of attorney can't make you the owner of property? We are going to deep dive in this topic today. Welcome to Tax Decoder, myself Anil Diwan. In a recent Supreme Court judgment, Ramesh Chandra versus Suresh Chandra and another decided on the 1st September 2025. It's a very recent judgment. This case is all about a family property dispute that raises some very important questions about how ownership in India is actually transferred. Let's begin with the background of the case. The property in the question was in Delhi and originally belonged to Shri Kundan Lal. He was the father of both the plaintiff Suresh Chandra and defendant Ramesh Chandra. Now Suresh Chandra went to court claiming that his father had transferred the property to him through a set of documents executed on May 16, 1996. These included an agreement to sell, a general power of attorney, and an affidavit, a receipt of money paid, and the registered will in his favor. Based on this, Suresh said he was the rightful owner and his brother Ramesh was merely living there as a licensee. Licensee is a person who is allowed to stay but without the rights. He further accused Ramesh of wrongfully selling half of the property to a third party, who then came in as a second defendant. On the other side, Ramesh Chandra argued that his father had orally transferred the property to him way back in 1973, and since then he had been living there continuously. He pointed out that in an earlier suit filed by Suresh in 1996, Suresh himself admitted that their father was still the owner of the property at that time. So, how could Suresh now suddenly claim that he had purchased the property in 1996? Ramesh also attacked the validity of the document. He said that an agreement to sell or a general power of attorney or a receipt do not make someone an owner. Only a registered sale deed can do that. He also argued that the will had not been proved according to law. Neither of the attesting witnesses properly testified, and the circumstances around the will were highly suspicious, especially since their father had four children but left everything to only one son. The third party defendant, number 2, also presented the arguments. He said that he had bought half of the property from Ramesh in a good faith. He paid the consideration and was in possession of the property. Therefore, as a bona fide purchaser, his right should be protected. It's true. Now, what did the court says on this point? The trial court sided with Suresh Chandra, holding that the documents were valid and dismissing the Ramesh counterclaim. The High Court of Delhi upheld this in 2012, but the Supreme Court had earlier clarified in Suraj Lamp and Industries versus State of Haryana that the GPA, that is General Power of Attorney, and agreement to sale are not sales under the law. That precedent mean that matter had to be reconsidered, and that is what brought in back before the Supreme Court in 2025. In its detailed finding, the Supreme Court carefully examined each argument. First, it held that an agreement to sell does not create ownership. Section 54 of the Transfer of Property Act makes it very clear only a registered sale deed can transfer the property. Our agreement is at best a promise that a sale deed will be executed in future. Second, a general power of attorney is just an agency agreement. It authorizes someone to act on behalf of another, but it does not convey the ownership. Even if it says that attorney can sell the property, it does not itself transfer ownership. Third, regarding the will, the court said a will must be proved strictly in connection with the law. That means at least one attesting witness must testify. Here, that did not happen properly, and surrounding circumstances raised suspicions. Why would a father disinherit three of his four children without any explanation? The court held that such a will could not be accepted as genuine. Next, the court looked at Section 53A of the Transfer of Property Act, which is the doctrine of part performance. These provisions allow a transferee in possession to defend his possession even if there is no registered sale deed. But in this case, since Suresh himself was suing for possession, it was clear that he was not in possession of the property. Therefore, he could not claim any protection under Section 53A. Finally, the court ruled that since the document did not confer ownership and will was not proved, the property would devolve by succession. That means all class 1 heirs of the deceased father, Shri Kundan Lal, would inherit equally. They are the equal one of the property as a legal inheritance. As of the second defendant who purchased half of the property, the court protected his rights, but only to the extent of the shares that Ramesh himself was entitled to. In conclusion, the Supreme Court set aside the High Court judgment and dismissed the plaintiff's suit. The key takeaway from this case is crystal clear. In India, the ownership of immovable property can only pass through a proper stamped and registered sale deed. Agreements, then general power of attorneys, affidavits, receipts, or even doubtful wills are not enough to prove the ownership. For buyers, the lesson is simple: always insist on a registered sale deed. For families, it's a reminder that unclear arrangements can lead to decades of litigations. That's all for today's detailed breakdown of Ramesh Chandra versus Suresh Chandra. You have been listening to Tax Decoder by Anil Diwan. If you enjoyed this episode, share it with your friends, colleagues, or students who want to understand how property law really works in India. Until next time, stay informed, stay compliant, and stay ahead. Thank you.